Eviction process in Virginia, laws for landlords and property managers. Ever wonder what the eviction process looks like in Virginia? Let's learn all about it. Today, we will be breaking down the eviction process in Virginia, which is also known as unlawful detainer. The process can differ from county to county, but they are more or less the same. Send a clear written notice, fill out the forms, serve the documents, attend the trial, and wait for judgment. This video is a summary for landlords to refer to when beginning an eviction process. Remember, if you have any specific questions, don't hesitate to contact an attorney. Get our guide to eviction laws on the go from DoorLoop's Landlords Guide series. Click the link in the description. Now, let's get started. The first step to any eviction is providing an eviction notice. This notice is usually a form that is filled out by the landlord that details the tenant's violation and whether or not the tenant can fix the issue. The notice period depends on the reason for eviction. This form is important because without it, the tenants may easily win the case. Eviction reasons: failure to pay rent or non-payment of rent. The most common reason to begin an eviction process is the failure to make a timely rent payment. A landlord can evict a tenant for failing to pay the rent due. Rent is considered late in Virginia depending on what is stated in the lease agreement. Grace periods, rules on late fees, etc. are also addressed in this agreement. In tenancies that do not have a written lease agreement, rent is due on the first day of every month. Rent is considered late if it remains unpaid on the 5th day. Before a landlord can start with the eviction action for not paying rent, the landlord must provide a notice to the tenant called a 5-day notice to pay. This written notice informs the renter that they must move out of the property or pay the rent due in 5 days to avoid eviction. If tenants who are being evicted for failing to pay rent on time manage to pay all rental payments in full to the landlord before the 5-day notice period is up, the entire eviction process stops, and they can continue staying within the rental premises. Violation of the lease or rental agreement. A lease agreement can vary between tenants. Landlords and tenants are required to uphold the terms of the lease agreement at all times. In Virginia, landlords can evict tenants for a lease violation. The landlord must give tenants a 30-day notice to comply, which provides them with 21 days to fix the issue. Should the tenant be unable to resolve the issue within 21 days, the tenant has the remaining 9 days to vacate the rental property. Lease violations include damage to the rental unit, smoking in non-smoking areas, material health and safety violations, too many people are living inside the rental unit, and housing a pet in a pet-free rental unit or rental premises, etc. The landlord may continue filing for an eviction lawsuit if the tenant fails to resolve the issue and remains inside the rental unit after the given notice period. This only applies to curable violations. In the case of non-curable violations, the landlord must only present a 30-day notice to quit. In these cases, the tenant must vacate the property within 30 days. They are not allowed to fix their violation. Conducting illegal activity. If a tenant in Virginia has engaged in illegal activity on the rental premises, the landlord is not legally obtained to give them any notice. Landlords may proceed directly to the next step in the eviction process and file an eviction. Examples of illegal activity are, but are not limited to, involvement in the creation, distribution, or consumption of a controlled substance, and violence that threatens the health and safety of other people residing within the rental property. Non-renewal of lease after the end of the rental period. A Virginia eviction process does not allow a landlord to evict a tenant without good cause. As long as the tenant does not violate any rules, they can stay until their rental period ends. However, a tenant can be evicted if they stay in the property even a day after their written lease ends and have not arranged for renewal. This type of eviction notice usually only applies if the landlord wants to end the tenant's rental term. The landlord must provide a written notice. The notice must be the right one, depending on the tenancy type. Should the tenant remain in the rental premises even after their notice period ends, the landlord may continue to file an eviction lawsuit in order to evict the tenant from the property. For your own Virginia lease agreement, visit DoorLoop's forms page by clicking the link in the description. Filing a lawsuit. After the notice period has passed, the landlord may file an unlawful detainer in the correct circuit of General District Court. Successful evictions rely on correct filings, so the landlord must file all of the forms correctly. Steps in filing. Proceed to the court or general district court the rental property belongs to, fill out the forms, and pay the filing fees. Filing costs can rise as high as $151 in Arlington Circuit Court. Timeline. It takes between 5 to 30 days before the landlord can file a complaint. This depends on the notice given to the tenant. Notice to comply. Before filing for an eviction with the court, you need to issue the tenant a notice to comply. You can either download the free PDF or Word template or create your Virginia eviction notice from the link in the description by using a step-by-step wizard that guides you through the entire process to make sure you are submitting the legally correct notice. Keep in mind, this step-by-step wizard will ask you to pay a small fee at the end. It's a small price to pay to ensure legal compliance and protection. The last thing you want is to go to court only to find out you did the first process incorrectly. Serving the tenant. The summons and complaint must be served to the tenant. The landlord must not serve this document themselves. The document should contain information such as the date and time of the court trial. The state of Virginia allows a professional process server, a sheriff, or individuals who are at least 18 years old and uninvolved in the case to serve the document. Anyone in the sheriff's office may also deliver the documents. It has to be delivered at least 10 days before the eviction hearing is scheduled. How to serve documents to a tenant. The summons and its corresponding documents have to be served through one of the following methods. Personal service. The summons and complaint is served to the tenant in person. Substituted service. A copy of the summons and complaint may be left with the family member. Posting and mailing service. A copy of the summons and complaint is left in a secure and visible position by the entrance of the tenant's rented property. When used, this method must also be accompanied by mailing another copy to the tenant. Publishing service. The server requires another court order to publish the summons and complaint in the local newspaper. After serving the summons and complaint, a tenant is not required to file a written answer or appearance to the court. They only have to show up to the hearing. Timeline. The summons and complaint must be served at least 10 days before an eviction hearing is scheduled. Asking for possession. Filing a motion to obtain judgment and get a judgment for possession. A landlord has to provide a strong argument backed up by solid evidence against their tenant in order to win. Should the tenant fail to show up to the hearing, there's a chance that the judge rules in favor of the landlord immediately. Next procedure if the tenant disagreed and filed an answer. During the court hearing, the landlord has to support their claim with evidence and show it to the judge. This includes, but is not limited by, the following: copy of the deed and the lease, rental agreement, rent receipts, rent ledgers, bank statements, witness statements, and photo and video documentation of the violations committed by the tenant. An eviction hearing is scheduled within 21 to 30 days after the landlord filed the complaint. Getting possession. After the landlord wins the case and gets a writ of eviction. Once the landlord wins the case, and provided the tenant does not file for an appeal or reconsideration, the court will issue a writ of possession, often known as writ of eviction in the state of Virginia, upon the landlord's request. The writ of possession or eviction is released 10 days after the landlord wins the case. However, should a landlord fail to request for a writ of eviction by the end of the 180 days after winning the case, they have to start the eviction process from the beginning. The writ of eviction is a court order which informs the tenant that they must move out of their housing on the property or else they will be forcibly evicted. Move out process. This final step in the eviction process is to move the tenant out of their housing on the property. Virginia law dictates that the writ must be delivered to the tenant from the sheriff's office within 15 to 30 days upon its issuance. Often, only the sheriff can enforce the writ on the property. Once tenants receive the writ, they must vacate the property within 72 hours. Only the proper law enforcement officials, such as the sheriff, can evict the tenant from the property forcibly. It is illegal for the tenant to do a self-help eviction even if they have won the case. Virginia eviction process timeline. Evictions in the state of Virginia take an average of 2 to 4 months. Showing evidence. How to keep good records. If the tenant disagrees with the eviction request and they reply to the court, you must keep outstanding records of everything to provide proof to the judge and win your case. This part can make or break your entire eviction request in the event of a dispute. You can stay organized by keeping a physical paper trail. This gets very hard to search through, takes up a lot of storage space, and could be damaged or lost in many scenarios. Scanning documents. Scan every document into your computer. Backups. Store and backup every file using Dropbox, Google Drive, OneDrive, or any other easily searchable option. PMS. Use a property management software to save everything from lease agreements, signed documents, violations, emails, notes, invoices, payments, reminders, maintenance requests, pictures, videos, and anything else that can possibly be useful in a court case. This is best used when every single document is scanned into the software. Evidence to show for not paying rent. If the tenant doesn't pay rent and they dispute this claim, you must show the judge the following: your lease agreement, showing the terms of the agreement, when rent is due, and any penalties for late payment, all payments, showing all previous payments, how they were typically made, check, credit card, ACH, etc., and what date they were usually paid on. Any payment returns. If their check bounced, their bank account had insufficient funds, or they did a chargeback dispute on their credit card, show this to the judge. Also, any fees or charges that have been charged to your account can be claimed in the agreement. All messages. If you sent your tenant automated or manual payment reminders by text, email, letter, or mail, it's essential to show this. While it's usually not needed, it's still good to show that they were aware of the situation and were given time to cure and make payment. This is why it's always best to have everything in writing instead of any phone calls or face-to-face meetings. Evidence to show for lease violations. If you're evicting the tenant for lease violations, for example, noise complaints, unauthorized pets, or property damages, it's important to show proof from any of the following methods. Security cameras. If you have a surveillance system that can show them committing the crime or lease violation, it's safe to say you will typically win this dispute. Video. If you miss them in the act, the next best thing to do is to record a video with your phone of any damages or the lease violation. Pictures. They say a picture is worth 1,000 words. In this case, a picture could be worth thousands of dollars. Even if you take a video, it's important to show the judge any pictures too, as it will usually be more useful than any other sort of printed evidence. Lease terms. Once again, show the court which term they violated in their lease agreement. Don't worry if you don't have every single term spelled out in your rental agreement. If the violation is bad enough, it might not be needed to have it written. As a good practice though, start adding all of the potential reasons to evict a tenant into your agreement. Before I go on to talk about self-help evictions, don't forget to like, comment, and subscribe for more amazing content. Self-help evictions. Examples of illegal self-help evictions include changing the locks, taking the tenant's belongings, removing the front door, or turning off the heat or electricity. Many states specify how much money a tenant can sue for if the landlord has tried to legally evict the tenant through some sort of self-help measure. Some state laws also provide for tenants' court costs and attorney's fees if the tenant successfully sues the landlord, and/or give the tenant the right to stay in the rental unit. And that's it. Thank you for watching this video. For more valuable content, join our exclusive Facebook community with the link in the description. And to learn more, feel free to check out these videos. Thank you and have an amazing day.